Hello everyone, today we will discuss another topic under banking and insurance law. Today's topic is the application of Consumer Protection Act 1986 under insurance sector. Here we will see that different courts have taken this view that the policyholder is or has the position of a consumer as per the Consumer Protection Act 1986. We will discuss the concept here. The list of topics to be covered here is Introduction, the Consumer Protection Act 1986, which has the three-tier redressal system. We will see how the court has come up with the view that beneficiary of an insurance policy is a consumer. We will discuss the role of surveyors under the insurance claim process and different case studies. With the expansion in the insurance sector, more private players have entered, which usually focuses on the marketing of their products and not on consumer satisfaction. This particular statement has been applied in the insurance sector because as the insurance sector has been liberalized, various private players have entered in the area and they were more focused on the policies they sell in the market, not on the requirements of the consumer and the consumer satisfaction. Thus, there is a need for the protection of consumers under insurance sector. This is why the Protection of Consumer Act in 1986 is made applicable to insurance sector also. Consumer Protection Act 1986 is an act to provide for better protection of the interest of consumers and for that purpose to make provision for the establishment of consumer councils and other authorities for the settlement of consumers' disputes and for matters connected therewith. Insurers are also required to set up grievance cells and their performance is monitored by them on a regular basis, but it is submitted that a speedy mechanism for redressal of the grievances of the policyholders has been provided under the Consumer Protection Act 1986. This act provides three-tier redressal system. The three-tier redressal system consists of, at the district level, the redressal agency is known as Consumer Disputes Redressal Forum. At the state level, the redressal agency is known as the Consumer Disputes Redressal Commission, which is every state has their own. And at the national level, there is a single redressal agency which is known as the National Consumer Disputes Redressal Commission. The district redressal agencies have jurisdiction to entertain the complaints against insurers of life policies and other policies up to Rs 20 lakhs. The state redressal agencies have jurisdiction to entertain the complaints of against the insurers of insurance policies above 20 lakhs but within 1 crore rupees, and the National Redressal Agency have jurisdiction to entertain the complaint against insurer of insurance policy exceeds 1 crore rupees. Now, the view beneficiary is consumer has been taken up by Supreme Court in the matter of Canara Bank versus United Indian Insurance Corporation and others. On February 6, 2020, the Supreme Court held that the beneficiaries of the policies taken out by the insured are also consumers under the Consumer Protection Act, even though they are not parties to the contract of insurance. Role of surveyors. When a beneficiary lodges a complaint with insurance company to claim damages as per his insurance policy, the insurance company sends a surveyor. Surveyors are professionals who assess the loss or damage and serve as a link between the insurer and insured. They usually function only in non-life business. Their job is to assess the actual loss and avoid false claims. Surveyors, like agents, are not employees but are independent professionals hired by the insurance companies. The insurance business operates on the principle of indemnity, that is, putting the customer in same position financially in which he was before the loss has happened. As there is a tendency on the part of customer to benefit out of an insurance transaction, the surveyor puts a check on that and assesses the loss. He then gives a report to the insurance company, and based on the surveyor's report, the company will settle the claim. But in today's scenario, it has seen that the insurance company tries to ignore the report submitted by one surveyor and keep on appointing surveyors one after another unless they get favorable report. In many cases, it has been observed by the Honorable Court that the insured getting harassed from professional attitude of the insurance company. This amounted to unfair trade practices on part of the insurance company that affected not only to the complainant but also to public in general. In Mulangi Spintex Private Limited versus New India Assurance Company Limited in 2007, National Consumer Dispute Redressal Commission, the complainant filed complaint that the insurance company is pressurizing him to settle the matter on amount based on the report of the second surveyor. The complainant had taken policy from the respondent to insure the machinery of the plants. Due to fire, all machinery become worthless. The complainant moved application for claim before the insurance company. The insurance company ignored the report presented by the first surveyor who had personally visited the burned premises. The insurance company appointed second surveyor and compelled the insured to give the consent on the amount based on the report of second surveyor, which was based on incomplete and false evidence. The National Commission held that how the surveyor of the insurance company can ruin the insured industry or the firm by underestimating the loss suffered due to contemplated peril, and how insurance company can coerce the insured to accept it in full and final settlement. Both things are deficiency in services and unfair practice on the behalf of the insurance company. So we can conclude that there are many cases where insurance company controlled the claim settlement process as per their terms and conditions and ignored the actual loss and damage caused to the policyholder. Thus, there is a need for the consumer protection under the Consumer Protection Act 1986.